Cammisa Markel, principal and founder of Cammisa Markel. Zjantelle, thank you for jumping on. I know that you and I text back and forth. We were sort of saying it's Friday before Memorial Day. What a time to release a memo and throw us all into sort of a bit of confusion. I know one of the big things for you is around like calming people down, really separating fact from fiction. It's very easy in topics like this one for people to get nervous and worried, understandably, when they start reading things online or starting to see information. So I very much appreciate you jumping on here at the drop of a hat so that we can quickly go through what we do know right now and what we don't know about the changes to green cards and adjustments of status. Before I let you talk, because I've done my whole thing, I'm going to do a quick disclaimer because the information in this presentation is provided for general information purposes only and does not constitute legal advice, professional advice, or personal guidance. It is of a general nature and does not take into account your individual objectives, circumstances, or needs. You should not rely on this information as a substitute for obtaining specific legal or professional advice. Before making any decision or taking any action in relation to your particular circumstances, we strongly recommend that you seek advice from a qualified legal professional. Neither Zjantelle Cammisa Markel, Josh, nor America Josh accept any responsibility or liability for any loss arising from the reliance on information provided in this presentation. It's always the fun part, Zjantelle. Thank you for joining us.
Audition for the ads where they sell the medicines and then.
That's my next, the next webinar right after this one. But Zjantelle, do you want to just start off 30,000 feet? What was announced in the memo last Friday?
Okay, great. So USCIS issued a memo to the immigration officers that adjudicate adjustment of status cases. It did not create a new law. The law for adjustment of status remains as is, but what it did remind USCIS officers is that they have broad discretion when it comes to adjudicating those cases. And they've reminded them that, in their words, adjustment of status is a matter of discretion and administrative grace, right? So they have proceeded to say, to guide those immigration officers in their adjudication and basically saying, weigh up these factors. When someone applies for adjustment of status, weigh up whether they are worthy of adjustment of status. Consider if there are any negative factors, if there are positive factors. Zach Carla did make a statement which is a little bit helps to calm people down, which is that people who provide an economic benefit or if it's otherwise in the national interest to approve someone for adjustment of status, that those people should likely get approved for adjustment of status. So I think what we're looking at here is immigration officers are just reminded that you can deny someone if there are negative factors that outweigh positive factors, and that's written in the memo. If the immigration officer is going to deny someone, they do need to write up a report and list the negative factors that outweigh any positive factors to substantiate that denial. So I think that's also really important to note.
So is that all of this was already in place? Like you were sort of saying that this is a reminder that they can exercise this discretion. But why the reminder? Sorry, yeah, sure.
That's right. People can apply for adjustment of status and still get denied adjustment of status historically, right? So if you've ever violated the terms of your visa, if you have ever committed a criminal offence that's considered a crime involving moral turpitude, you could be inadmissible to the United States. If you're inadmissible to the United States, then there are instances where your adjustment of status would get denied anyway. So not only in looking at that, I think what the memo is guiding officers to do is to look beyond even just factors that make someone inadmissible, but factors that make them maybe not a person that the United States would like to have in the United States. So they're citing factors such as even good moral character, for example.
Okay, so previous to this, there wasn't like a descriptive list, or is it the same list that's already, like, for these officers, they've already seen sort of the list of things that they would have assessed someone against? Has that changed, or is it still the same sort of?
It's still the same factors. And
okay.
If you look at what they say that immigration officers should factor in, which include whether the person has any criminal history or arrests, whether they have immigration violations, including any overstays or unlawful presence, how they entered the country. Did they enter the country fraudulently? have they had any unauthorized employment in the United States? Were they complying with the terms of their visa once they did enter in on a visa? For example, did they come in on an F1 visa and then not study at the university? Did they enter in on an E3 for this crowd and then not work for that employer, or stop working for that employer and then hang out in the United States on that visa? So they're looking at things like, did you comply with the terms of your visa? Other things that they're looking at is just general good moral character, overall immigration history. Have you ever lied for an immigration benefit? That's an important one too. You know, just quick side story, we just saw that someone had an issue, which has never been an issue before, in relation to, and this just blows my mind, a fake ID that he applied for when he went to college in the United States, and he is not from the United States. So he was here on an F1 visa, he applied for a fake ID. Just mind you that in his home country, he's legal to drink and everything, right? Because
sure.
He's 18. So he gets to the United States, all his American friends that are applying for fake ID, they say, let's get you a fake ID too. This has now come back to bite him, so to speak, because they consider this to have been a fraudulent activity. And
okay, so if the scope hasn't changed and this is a reminder, I guess why issue the memo? Like, is this normal that we'd see a memo saying, like, just reminding you of like what you're meant to do in this public way?
So for this crowd, I don't think this memo had E3, specifically E3 visa holders in mind. I think the crowd that this memo has in mind, and it states it in the memo, are those who are here that most likely would get denied their adjustment of status anyway. So what happens is it's easier to deny someone re-entry to the United States than it is to remove someone from the United States. So if you now say everyone has to consular process, if that person's case is going to get denied and they're outside the United States, they can't get back in.
Yes.
If someone goes to their adjustment of status interview and their adjustment of status interview, green card gets denied at the adjustment of status interview, they have to go through a removal process, which is very lengthy and costly to the United States. And as the memo suggests, there are people that slip into the bushes, or I can't remember the exact wording that he said, but people slip in. So I think that this is aimed at, which is what we've seen from this administration, trying to get those with a criminal history to get those out of the US, and it's easier to get them out if they're out and trying to get back in, if that makes sense.
Yeah, okay. So for the people like tuning in tonight, I know there's like the vast majority would be E3 holders, and if this isn't sort of really focused on them, what are your, and I realize we're sort of crystal balling this because we don't know, there's clarifications to come, but what do you think the actual impact will be for, and we'll start with people who have not yet applied, so they are someone that might at some point in the future have had in their plan that they would be using an adjustment of status to get a green card through either family or through work. What do you think the real world implications of this, as you see it at the moment, are?
Amazing question, because while it might not have been aimed at E3s, it's still going to affect people.
You sweep them up, right? Yeah.
So if you have not yet applied for adjustment of status and you're on an E3, this affects you if you are planning to apply for a green card, whether through marriage, and a family-based petition, or employment-based, right?
Yep.
So at the outset, I don't think you should change the way you approach your green card case, in the sense that you should sit down with your immigration attorney and make a conscious decision as to whether you're going to consular process or apply for adjustment of status. And I just want to make it clear that there are often times when people on an E3 are applying for a green card, and consular processing is naturally the best choice anyway. And often that might be if the person has international trips that they really need to go on, or their jobs necessitate frequent international trips, because we know that the adjustment of status process does have a period where people on an E3, going from E3 to green card, will necessarily have a period where they can't travel internationally. So there are already Australians on E3s that are choosing consular processing, right, over adjustment of status already, because it's the best choice
for them.
Now, if your attorney decides that adjustment of status is a better choice for you, for multiple reasons, you might have children of a certain age, You might have, you need that EAD that comes with adjustment of status. There are certain factors, and your immigration attorney will list those. They will take up a whole half an hour if I go through all that now. But if, say, you determine that adjustment of status is better for your particular set of circumstances, I think what we need to determine now is your immigration attorney will want to prepare you for if there is a interview for your adjustment of status for to help you to outline and maybe prepare a supplemental packet, which is what I think we intend to do moving forward, that provide what are the positive aspects of
why are you so good
adjusting this person. How are
yeah.
you going to be in the economic interest of the United States? How are you going to benefit the United States? What is it that you're already doing? Does your job create more jobs for US citizens here? Does your job benefit the United States? Do you have family members that require you to be here? Have you been a philanthropist? Have you done any other charitable activity while you're here? And if you're not the one creating the jobs through your employment, would your employer who is a major contributor to the economy, be severely affected if you could not remain here and go through the adjustment of status process? So I think this is the supplemental information that you'd want to put into your application because of the wording that they used in the memo, which is that granting adjustment of status is an extraordinary act of administrative grace and will be granted only in extraordinary circumstances. So what we don't know is what is their definition
How graceful.
of extraordinary circumstances. The memo kind of contradicts itself, right? Because it also says that, if dual intent visas, so those are the H1B ones, most likely won't have an impact, right? They should be fine to.
This is kind of the point of
status.
yeah.
So in those instances, it's not, extraordinary circumstances that will allow them to get to be approved for adjustment of status. So so I think supplementing your paperwork and thinking about that, how can you show
telling a story?
And I think what's really important is the only way your immigration attorney can help you is if you disclose everything to your immigration attorney. Your immigration attorney is not going to publicise it. There's attorney-client privilege that protects that. But the only way they can protect your case is by knowing that. I know we have a form when we meet with our clients and it says, have you ever been arrested? And clients often say no. And then in the consultation, I'll say, have you ever been arrested? And I don't know why, but the magic 3 times of saying ever then leads people to say, well, there was one time. And it's there was this one time that is going to be critical now for you to share.
Especially if you don't disclose
Exactly. So they can defend you against whatever that thing is. You don't want that surprise coming out at your interview.
Got it. You mentioned the dual intent visas, like H1Bs. The E3 is not one of those dual intent visas. It does not fit into that category. So do you think there will be, like, if we're sort of assuming that from the memo it says, this is not the purpose of changing the behavior for a dual intent visa, therefore does that imply that for an E3 you're going to have to really make a case for it? Like, is it you're really, and I understand the whole point of this is that it's like that's what they're saying, you have to make a case, but like how difficult, like for Joe Schmo who might not be doing anything outlandish, they've got a job, they have a partner potentially, and I know that you, again, this is sort of speculation and I don't want to sort of put you in a box, but is your instinct that most applicants, if there's no do you promise you've never committed a crime, if there's nothing like that, is there any reason to think that people won't be extended this grace? Or we just don't know? You can say that, that's fine.
I don't know for sure, right? That is the way I am thinking. I'm thinking that most people that have a clean history, clean case, have
job, partner, whatever it is,
immigration status, should be fine to adjust status as long as they supplement it, right? The other reason why I think that is because if you read the memo carefully, it says that entering in on a non-immigrant visa, that is a single intent visa, not the dual intent visa, can be considered a negative factor. But they do also say if that is usually accompanied by their violation of our immigration laws.
Right.
So I think if you came in on an E3 or a B or an F or one of these single intent visas and you have a violation of immigration law in some other respect, then I think
Then
you
it's gonna be
have
hard.
a difficult case. Yes.
Yeah, yeah, okay. But if you're, yeah, okay. Then there's the group of people who may already have I-485s or adjustments of status in, and I know that we got a lot of questions around this. What are you telling your clients? What do you feel what the prospects are for them?
Yeah. I think I just want to one thing
Sure.
back on the
Yep.
consular processing side of people that are on E3s is that I think that also we will start to see a backlog of interviews as well. But
For
coming back to
at the consular
the
processing.
consulate, like
Yeah.
we did with the E3 visa interviews,
Yes, yeah.
right? Because everyone is going home now to do their visas. So on those who have filed adjustment of status already, there's not much you can do right now, right?
Yep.
Until and if you get scheduled for a green card interview. So at the moment, marriage-based green card cases are scheduled for a green card interview. A lot of employment-based cases have been able to be approved their green card and adjustment of status without an interview.
Yep.
Now, under the last term, Trump administration's last term, we did see a mandatory return of everybody having to sit a green card interview, including employment-based adjustment of status cases.
Yep.
So it would be interesting to see if employment-based cases now will require a green card interview. We're already seeing one with a client of ours, and we're wondering if this is in conjunction with the memo. We'll find out. But as this plays out, and as we see clients, we're going to go to marriage-based green card interviews, and we'll see how this memo affects these cases. And also, we'll start to see whether it's going to be a pattern now that employment-based green card cases will start to get interviewed. And if so, what those people that have already filed their adjustment of status, coming back to the question, can do is, again, think about those factors that make you a positive member of the United States, someone who does provide an economic benefit to the United States, or that it's in the national interest to adjust you in the United States. So start thinking of those things that you do and provide that evidence, gather the evidence and provide that to your immigration attorney.
Okay. Prior to now, the adjustment of status or the consular path, are they relatively similar, like in sort of what you'd normally present? Just so I understand, like, and I know that people might be thinking, like, if I have to go down this consular path, is it, apart from the fact that you're outside the country, and we'll come to sort of timing in a second, but is the process similar?
Is a little bit different in that when you file for adjustment of status, you are doing the whole process within the United States. You go for fingerprinting in the United States, and they do an FBI background check on you, and that's how they get all of your police checks from all other countries where you've ever lived and so forth, and then everything happens within the US.
Yeah.
If you do a consular processing, the documents that you have to submit are a little bit different because you don't do fingerprinting
Have that.
the same
Got
way.
it. Okay.
So you need to get police certificates from every country that you've lived in for more than 6 months after the age of 16, right? So it's a little bit more document intensive. And the other thing is that when you get scheduled for your green card interview, you will have to fly back to Australia to attend it.
Sure.
And we try to recommend clients to really attend that interview when they're scheduled it, even if it's inconvenient, because getting it rescheduled can sometimes be problematic and make the case really go for much longer.
Yeah. So but prior to this change, if you were going for the consular process, how, like, can people stay in the country until their appointment, then fly out to Australia, do the appointment, and then wait a period and come back? And what is the sort of timing there? Or do they have to leave as soon as they apply? Like, what's the sort of process?
That is such a fantastic question, because I feel like the media makes it seem like you have to leave as soon as you
apply
for your consular processing. This is not the case.
Okay.
You can be in the US, continue working in the US up until the date of your appointment, and then leave, go do your green card appointment. And it's like a visa appointment, right? It's a non-immigrant visa sticker that you get put in your passport that you then re-enter the United States with. But if you're going to do that, the whole time that you're in the US, you must maintain your non-immigrant status. So you can't just fall out of status while you're here, which means, maintaining your status, abiding by the immigration laws, renewing your visa if you need to, if it expires during that period. So that's very important. Otherwise, you'll leave, and if you violated the immigration laws or overstayed your visa, you'll be inadmissible and will not be able to get that green card and come back.
Okay. I like that renewing the visa. So that is a possibility even on an E3, like the single intent visa. So if you've put in the application for consular processing, you're waiting for your appointment to come up, and your visa is expiring, you cannot lapse in status because you need to maintain this status, as you just said. You can, in fact, like renew your visa with their pending adjustment, or not adjustment, pending application for a green card.
You can, you just need to be very, so I think with consular processing, with both cases, right, adjustment of status and consular processing, and really more so with consular processing, if you're moving from an E3 to the green card, you need to be really careful and strategic with the timing of how you approach it, and how you approach the renewals as well.
Yeah.
So what I think we might see more of now is, so previously there was this misconception that you needed an H1B before getting a green card. You were on an E3.
Yes.
And that's not the case, right? You can go E3 to green card. But with this memo, and for people that are nervous, it might be good for those people to transition to an H1B and then a green card, because in that instance, you have a little bit more.
There is a clearer pathway.
Security that you're going to be fine.
Okay. Do we think, I'm sorry, and just the last one on timing, if you've left the country, what is the sort of normal turnaround when you do the interview in Sydney, say, and you've had your green card interview? How long do people normally have to wait? Is it the same as like getting an E3 sticker, and it can be a couple of weeks and you're back on a plane?
Yeah, so it's exactly the same. It can take as little as a week.
Yep.
Or as long as much longer
many,
than that.
Many.
And
Yeah.
it's the same with visas at the moment.
Yes. Yeah.
So,
yeah.
You know, there are people that have been issued, just want to remind people, that are people right now that have been issued E3s multiple times before that took a week, that are now taking 3-4 weeks if they have something like an arrest or DUI in their history.
Yes.
So if everything is clean in your case, it should go straight forward, a week. But if there's anything, if your name comes up on a name check or anything like that, it could send it into administrative processing, just like a visa can.
Okay. And from your experience with memos like this, do we normally see like specific clarifications for types of visas and legal sort of workings that happen in the next few weeks and months? Like, what should people be watching out for? And I want to make sure that people don't spend their entire time glued to a television trying to worry about like the next, but what are the, like, what's the normal process?
Give people an update.
Correct. Yes. It'll be another one of these if there's anything. Yeah.
Yeah. I don't think that I would be surprised if they single out the E3, in this, but maybe the E3 will become lumped into a category of non-immigrant visas or single intent visas.
Yep.
And how immigration officers should specifically deal with those. And I think that the other carve-outs will most likely be more for the groups like the refugees, the people like, right now there's a ban on issuing immigrant visas to 72 countries, right? So those people can't go on consular process because they're the consulates are banned from issuing them their immigrant visas.
Right.
That does not include Australia, but of the more common countries, it does include Brazil and Thailand. But our audience here should not be affected by that. But I think it's going to, if where they do say we're going to give more guidance, I think it's going to be for where the law contradicts with some other proclamation that's out there.
Yeah, okay. So there will no doubt be lots more communication on this, and there will be a discussion. It's just, for the moment, so to distill it all down, it's basically going to become a bit more of a presentation to qualify for an adjustment of status. So if you're in the country and you are on your E3 and you're working and you potentially marry someone, for example, or your employer wants to sponsor you on an E3, the process still exists, importantly. So you started by saying like nothing legally changed in like the statute. So it's still a possibility. It's more about building a presentation, and I'm sure, part of your entire job for your the clients that come to you is around sort of telling this story, and it is making a case, and there's a column of good things and a column of bad things, and you want to pick as many of the good things as you possibly can and say like, here's how I tick all of those boxes, and here how I definitely avoid any of the negative boxes. That is it's just going to become part and parcel of the application. It's going to be an extra, as you said, packet. Am I sort of distilling that?
I just want to make clear, Josh, that for the people that have maybe submitted their case on Friday, right?
Yes, yeah.
Thursday, and they're like, oh my gosh, I didn't include that. I don't think it's important that it even necessarily be included in the initial filing, as long as you have that at your interview if you're a marriage-based case, right?
Okay.
Because when you're for the marriage-based green card cases, you are necessarily going to get scheduled for an interview, at which point you're taking extra documentation anyway. So if you didn't get a chance to submit that already, don't panic.
Don't panic, okay.
You don't have to include this additional information already now. You will have the opportunity to do that.
And sorry, so this decision of whether you qualify for an adjustment of status happens at the interview stage for a marriage-based...
For a marriage-based applicant, yes.
Yeah.
So
okay.
They have not predetermined whether you qualify for adjustment of status until that interview is complete. They're going to ask you, and this is why prep for that interview is really important. Actually.
Yes. Okay.
So make sure your immigration attorney sits down with you, checks the documents that you're taking with you, and does like a mock interview with you.
Yep.
Prepare you for that green card interview as to what to say, what not to say.
Okay, and I just want to play it out. So in theory, you could do that. You could present your packet, and they could say, "Yep, we're all good. We're going to adjust your status, and you have now, like, congratulations, you've now got a green card." The other option is you could finish that interview, and they could say, "Sorry, no, we don't believe." Like, they're not saying you're not a candidate for a green card. They're saying we don't believe that you qualify for adjustment of status. You now have to leave the country and apply again. Is that the idea?
Yes. So if you're applying, let's just use the marriage-based green card as a process.
Yes. Yeah.
You file an I-130, which is the spouse applying for their partner for the green card, and then there's the adjustment of status. So the I-130 part of the case can still be approved,
okay.
And then that can be used to then consular process the case.
Okay.
So you would need to switch the case at that point to consular processing, or you would really want to see why it was denied. Actually, I think before you make that decision to consular process. There is a third scenario there, so they can either approve you on the spot and say, we're going to recommend your case for approval. You'll get the approval notice in the mail. You'll get the green card later. They could say, we're denying you. If it's a marriage-based case, you usually get a Stokes interview or one other interview first before they fully deny you, unless you are really truly inadmissible, in which case they will deny you. And then the third case is, they might say, we want to recommend you for approval, but there's still some administrative processing that needs to happen.
Okay.
And so then your case might take maybe 2 or 3 months, but it does eventually get approved. And so I really wanted to share that, because if your case doesn't get immediately approved or denied and it's in limbo, it doesn't mean it's the end of the road and that you're going to get denied.
Yep. Okay. Zjantelle, founder and principal of Cammisa Markel, I can't thank you enough. I know that we powered through quite a lot here. I'm sure there will be lots more to tell, and if there's any updates, I have no doubt that we'll jump on another one of these and let everyone know. There's some questions that have come in that Zjantelle and I will share, and if there's anything we can, we'll make sure that we answer those in writing in the coming days, or we'll do another webinar if we think it qualifies. But I want to really thank you very much. I think we've put a few minds at ease. I think people... Take a deep breath, and obviously go speak to your immigration attorney. That is the most important thing. Call your immigration attorney.
And on that, call your immigration attorney, just also have a little bit of patience and extraordinary grace.
Yes,
with your attorney, because they are probably, like myself, inundated and probably worked all weekend to help calm everyone and yourselves. And this is also why, thank you so much, Josh, for giving this. Hopefully this gives a little bit of comfort to people. But if you do reach out to your immigration attorney and they can't respond right away, often it's because they're inundated, but they will get back. They will get to you.
They will. Zjantelle from Cammisa Markel, thank you very much. Thanks to everyone for watching. And if you need to recatch this, we're America Josh on YouTube or americajosh.com. Thanks, Zjantelle.
Thanks so much, Josh.